has asked me to inform you of the following. The final exam in this course is in F295 Haas. F295 Haas is located in the Haas School of Business on the east side of campus near Gailey Road. It should not be confused with the Haas Pavilion, which is the gymnasium next to RSF near Bancroft Way. Students get confused about the location of these two buildings during final exams, and we're trying to prevent this from happening. So I've done my duty. Where's the final? Haas. The final, I haven't finished writing it yet, but will be very short and sweet. The exact same format as the midterm. That is probably 3 short answer questions and 25 or so true false questions. It should take you 15 minutes, 20 minutes, half an hour, something like that. And you can stay as long as an hour and a half if you want to, but I don't know why you would. It will, as you guys use the term, not be cumulative in the sense that it will cover heavily emphasizing material since the midterm through this Thursday. Although you really shouldn't forget the Pentagon Papers, or, how the system works. But the specific questions will be about material since the midterm. And that'll be easy. Next Tuesday, a week from today, you can come if you wish to a review session, which will be like the review session for the midterm, where we'll go over the questions raised in each section of the material since the midterm. And if you have any lingering questions, we can try to clear them up at that time. The papers are here, and you will notice that there's an evaluation sheet attached to the paper and the draft. It's the last thing, which has a grade on it, and it has comments on the various things that were supposed to be covered in the paper, including the quality of the writing, which is very important. And a lot of the papers are, especially the ones that I touched, are very heavily edited. You put a draft in front of me and a red pen in my hand, and I can't resist crossing things out, adding things, correcting punctuation, and so on. Get them at the end of the class, and I'll leave plenty of time for you to come up and get them, so there won't be any rush. So today, we pick up where we left off with COPA, the son of CDA, the successor to the law that was struck down in Reno versus ACLU, that is the Communications Decency Act, and the wonderful opinion that Justice Stevens wrote in that case. And as I mentioned the other day, Congress got back to work right away as soon as the CDA case had been handed down, and tried to repair the defects, the constitutional defects that the court had found in the CDA. That's in the Child Online Protection Act of 1998, COPA. And the COPA differed from CDA in 3 significant ways. It was much narrower, or significantly narrower, in its coverage, in that it covered only material that appeared on the World Wide Web, as opposed to emailing anything that you could find on the internet. It simply applied to material on the World Wide Web that was put online for commercial purposes. So only material that was for commercial purpose. They didn't define that very well, so it's not clear what the scope of for commercial purposes was. It doesn't mean necessarily that the content was being sold the way pornography is sold on the web. And nonprofit organizations, Planned Parenthood and could sell paraphernalia, what have you, and that could be considered commercial purposes. It wasn't limited, commercial purposes, limited to for-profit commercial activities. And finally, the defined forbidden content that gave rise to criminal sanctions was material that is, quote, harmful to minors. And this time, the Congress put in a definition of what it considered forbidden, and it defined harmful to minors in a way that is just like the Miller versus California definition of obscenity, except with regard to each of the 3 elements, the definition tacks on with respect to minors, or for minors, so that it would have appeal to the prurient interest with respect to minors. Patently offensive description or depiction of sexual activities with respect to minors. No serious literary, artistic, scientific, political value for minors. Well, as soon as the law was enacted, the ACLU and a bunch of organizations and individuals sued in federal district court in Philadelphia to enjoin the Attorney General from enforcing the law. The district judge issued a preliminary injunction against enforcing the law, and the case went to the Court of Appeals for the Third Circuit, sitting in Philadelphia, which found that the law was unconstitutional, violative of the First Amendment, principally for the reason that it used community standards to judge whether the material was harmful to minors. That's the middle prong of the obscenity test, patently offensive as judged by contemporary community standards. And the Court of Appeals recognized that the World Wide Web is worldwide and doesn't relate to a particular community. And the effect of imposing a community standard on the forbidden material would make it possible for prosecutors to choose the least tolerant, most conservative community in the country in which to prosecute somebody for putting up material that may be perfectly acceptable, perfectly consonant with community standards where they live or where their business is. But the fact that it can be viewed anywhere in the country puts them at risk of prosecution in places where they've never been and don't particularly want to be. And the Court of Appeals said that violates the First Amendment. Well, the government took the case to the Supreme Court. John Ashcroft was George W. Bush's first Attorney General, and he took the case to the Supreme Court, which decided that the law was not unconstitutional simply because of its use of community standards to govern whether the material should be forbidden. The opinion in the case was written by Justice, wait a second, this is COPA 1. Go back to, COPA 1, the first time it was in the Supreme Court. Justice Thomas wrote the opinion saying that simply because the statute used community standards doesn't condemn it as unconstitutional. And the real reason, the court was not trying to hide this anyway, the court was fairly blunt about it, Justice Thomas in his opinion, the real reason that they didn't want to strike down the law because it included the community standards provision is because that would condemn all federal obscenity laws. Under Miller versus California, community standards is one part of the violation of community standards is one part of the test. And if the court threw out this law because the community standards was included in the calculus of illegality, that means that obscenity would be permitted on the internet. It wouldn't be permitted in any other medium, but if you can't use community standards on the internet, that would throw out all of the federal laws that affect material put on the internet, or at least on the World Wide Web. It would eliminate the possibility of prosecuting obscenity. And Thomas's blunt advice to people who were worried that they might be prosecuted because of the community standard was use some other medium. Don't put your stuff on the World Wide Web. You use a medium that can target communities whose standards you can live with. Well, having decided that the law passed muster on the community standards challenge, the court recognized that there were other alleged constitutional deficiencies in the law and remanded the case to the Court of Appeals to consider whether the law passed constitutional muster on other grounds, something other than including community standards. So the Court of Appeals went back to work, wrote another opinion, and decided that the law was unconstitutional because it was not narrowly tailored to serve a compelling government interest. It was overbroad in that it reached material that has constitutional protection, and it was vague, pretty much like the Reno case, overbroad and vague, at least in terms of First Amendment vagueness, where a criminal law threatens you with prosecution and you can't figure out when you step over the invisible line from permitted to forbidden territory. Well, the government took the case back to the Supreme Court for a second time, COPA 2. This time, the decision was written by Justice Anthony Kennedy, and it was quite different in tone. He pitched the decision not as though it's the last word on the case, but rather in terms of how a court should review preliminary injunctions, whether the district court had properly exercised its discretion in issuing an order against enforcement of the law. But there was plenty of talk in the decision about the merits, and the court found, as the Court of Appeals had, that COPA was not narrowly tailored, that it was overbroad, and that the law couldn't stand if there was a less restrictive alternative to criminal punishment. That is, a sanction in the law, or a way to structure the law, that would be less restrictive of speech than criminal prosecution of the person who put the material up. And Justice Kennedy zeroed in on software filters as the cure-all less restrictive means, certainly less restrictive than criminal prosecution, and Justice Kennedy said likely more effective in serving the government's goal, which after all is to protect children from exposure to material that may be harmful to them. And the court recognized, Justice Kennedy recognized that the software filters are not perfect, they're not foolproof, that they both overblock and underblock. That is, they block material that is perfectly innocent and innocuous, and they overblock in that they do block material, but I guess it's the same thing, right? Overblock. They underblock in the sense that they don't reach material. For example, the hardcore pornography that originates abroad. And they, let me ask you about filters. As you grew up, did your family computers have any filters on them to screen out anything at all? Anybody? Oh, sure. I imagine. And what did it screen out?
Like, I think anybody who about the pornography, like that could have like viruses on them. There's mostly virus protection.
You remember what filter it was? What it was called?
No.
I've lost track when they first came out with all this, and one of them was Net Nanny. And I think, yeah, Katie?
My dad didn't ask like whether we just on Facebook. If he did like a
Yeah.
video. It was like a different.
Yeah.
My parents did it, but I did it for little sister, so I went to school for kids or something like that. There's also like porn, like website that I consider like inappropriate.
That you considered inappropriate?
Yeah.
Or that the filter did?
You can set additional filters. I didn't have the standard thing.
Uh-huh. How old was your little sister? Sorry? Right, then how old were you when you imposed this kind of censorship on your little sister?
I was 16.
16? So, oh, you were an adult by then, so you could do this. The filters are there. They work to some extent. As you see from Justice Breyer's dissent in COPA 2, apparently they cannot distinguish dirty images, only words. They're word activated. So if you put in sex, you might not get anything, even though, for example, you couldn't get the syllabus in this course mentioned sex. He says you can't distinguish the hardest core pornographic image from the Venus de Milo because the software filter doesn't understand images. Can't distinguish images at all. It's all word activated. Justice Kennedy's opinion concluded that the government had failed to prove that software filters were less effective than the criminal prosecutions that could occur under COPA. The Bryner dissent is really quite interesting. One of his main points is that it's hard to imagine material that would not be obscene but would violate this law in the sense that it would be harmful to minors, because the definition of the two is exactly the same with the for minors or with respect to minors language tacked on. And he's saying, well, if it has prurient interest for adults, it's likely to have prurient interest for minors, except maybe toddlers who wouldn't have a clue what's going on. If it's patently offensive for grown-ups, it's probably going to be patently offensive for kids. And if it lacks serious literary, artistic, so on value for grown-ups, probably that's for kids. So the really only borderline cases, he said, might be condemned under this law that wouldn't be obscene. So that this law really doesn't reach any significant amount more protected speech for grown-ups than an obscenity law. And indeed, when you think about it, it's hard to figure out something that would violate this law that wouldn't also be considered obscene. And then he makes his point about not being able to, the filters being clumsy and not being able to distinguish images. And finally ends up throwing up his hands and saying, why is the court remanding this case for trial now? Saying the preliminary injunction was permissible and correctly entered. Now it's sent back for trial. What's going to be tried? The Bryner is saying, what did he say? What else was Congress supposed to do? 2 statutes, multiple court decisions. What do you expect? But the case was sent back for trial. And indeed, the district court again held a hearing, listened to expert testimony and so on, and again condemned the law. And the government again appealed to the Court of Appeals, which in 2008 decided that the preliminary injunction had been correctly entered, that filters, in fact, were quite effective. That was the focus of the trial, where the experts came in and testified how filters work, what they catch, what they don't. That filters were, in fact, reasonably effective, so that the law was not narrowly tailored, and it was also under-inclusive in that it didn't catch all of the foreign origin pornography, which couldn't be prosecuted here. It was overbroad, the Court of Appeals said again, because it included not just commercial pornographers, but all kinds of nonprofit sex education sites. Salon.com had some material that was arguably harmful to minors, including Kinsey Institute photographs and some Japanese erotic woodcuts and so on. And the Court of Appeals noted that the law is overbroad and not narrowly tailored because material that may be harmful to a 5-year-old may not be at all to a sophisticated 17-year-old. Yet all were prohibited. And the court also focused on the vagueness of the law, the fact that people would have to guess at the meaning of what might be harmful to minors, which minors, and so on. The government argued that the First Amendment doesn't prohibit Congress from adopting a belt and suspenders approach to addressing the compelling interest of protecting minors. The government argued we can use filters acting as the belt and COPA as the suspenders. We use both the criminal prosecution and filters. But the Court of Appeals said under the First Amendment, sort of lecturing the government about the First Amendment, under the First Amendment, if the belt works at least as effectively as the suspenders, then the government cannot prosecute people for not wearing suspenders. And so the Court of Appeals condemned the law again. The government took the case back to the Supreme Court for the third try, and this time in 2009, the court simply denied certiorari. The government had argued in pitching its case to the Supreme Court on petition for certiorari that only half the households in the country, and must be a lot fewer if this is representative of the country, if this class is representative of the community of the country, only half of the households in the country use filters. But COPA was dead, and COPA was not resurrected, and the Congress has not attempted another law, has not enacted another law to replace CDA and COPA, a general, let's try to get smut off the internet kind of law. The government was successful with, the Congress was successful with one law, the CIPA, the Children's Internet Protection Act. This was the result of COPA. Mukasey was Bush's final Attorney General and was not successful in getting the case reviewed again. Then the American Library Association case. This sounds ominous. The United States of America versus the American Library Association involved a bill that was sponsored by John McCain before he ran for president. And the law denied federal funding to public libraries, including school libraries, unless the libraries, the federal funding was for internet access for the library, so that students could get access to the internet at the library, didn't have a computer at home, or just as a matter of convenience. And the law denied federal funding to the libraries unless